Now let's talk about insolvency with part 1, intro and sequestration. So what is insolvency law? So this is the totality of rules regulating the situation where a debtor can't pay their debts, or where their total liabilities exceed their total assets, so the creditors can jointly apply for the sequestration of the debtor's estate. So the purpose of this procedure is to pay at least a dividend to all the concurrent creditors instead of satisfying only the claims of a few creditors. And the main objective is to provide for the orderly distribution of a debtor's assets, where these assets are insufficient to satisfy all the creditors' claims. So what are the debtor's options? So they have debt problems. They can get an administration order, so the debt mustn't exceed 50,000 Rand in this case. They can also get release if a debtor says they can't pay, that's an act of insolvency. They can also enter into a credit agreement, an NCA. And here there'll be debt counseling, debts get rearranged. Debtors can also go for voluntary surrender, but this is only if requirements are met. Now let's take a look at the creditors' options. So first they can go for individual collection. So first there's litigation, then execution, then they attach the property and sell. And then they can go for collective collection. So here there's sequestration, the law of insolvency, and assets won't satisfy a claim. So creditors can apply for sequestration. And the objective of the collective collection process is to pay at least a dividend, and it provides orderly distribution of assets. So the Insolvency Act is based on two principles: the creditor's right to satisfy claims by executing assets, and the concurrency of creditors, who stands where in line to get the money. So when the sequestration order is given, the debtor loses control of their estate. Control vests in the master, then in the trustee. The master appoints the trustee, then the trustee sells and pays the creditors. Secured, preferent, and concurrent creditors. Now let's talk about concursus creditorum exist. So creditors are dealt with in a group, not individually. No claim, no execution, no attachment. The debtor can't alienate property. Their contractual capacity is limited until they're rehabilitated. And then what is a debtor? Well, this is a natural person, partnership, deceased estate, trust, or the estate of a person incapable of handling their own affairs and someone who owes money. So the Companies Act 61 regulates liquidation of insolvent companies, and the Companies Act 71 regulates liquidation of solvent companies. So let's talk about jurisdiction. So only a high court can hear a sequestration application. The debtor is domiciled, the debtor owns or is entitled to property, and the debtor ordinarily resides, carries business at any time during the 12 months before the sequestration order. But then, what does sequestration do to a person's status? Well, it limits the debtor's capacity to contract, the capacity to litigate, and the capacity to hold office or earn an income. So now let's talk about voluntary surrender. So who can apply? Well, obviously the debtor, an agent, representative with special authority, curator bonus, and curator bonus is a person appointed to handle the estate of a person who's incapable of handling their own estate. Another person who can apply is an executor of a deceased estate. And if the debtor is married, both spouses must apply jointly. And this is if they're married in community of property. And then only the debtor will apply if it's out of community of property. And then ordinary partners apply jointly for surrender of partnership. So now let's talk about preliminary formalities for voluntary surrender. So this is the stuff you do before the court application. So the first step is that the debtor must publish a notice of intention to surrender their estate in the government gazette and newspaper where the debtor stays or trades or principal business is located. And this should be done 14 to 30 days before the court application. And the effect of the notice is that the assets can't be attached, the sheriff may not pay creditors after sales, money and assets must be transferred to the trustee, and then a temporary curator bonisto controls the estate. And then the second step is that the notice of surrender must be sent to all known addresses of creditors, SARS, employees, trade unions, etc. And this should be done within 7 days of publication of notice. And then the third step is preparing the statement of affairs to lie for inspection by creditors at the master's office. So this statement lists all the assets and liabilities. 2 copies should be sent to the master's office where the debtor resides. So 1 to the provincial master and 1 to the district master. So they don't send it to a local master. And it must be open for 14 days for inspection from the date of surrender. So the purpose of preliminary formalities is to inform creditors of the application and to enable creditors to object to the application. So what are the requirements to be met in court by the applicant debtor? Well, they have a burden of proof. The applicant debtor must prove that preliminary formalities were met, they're in fact insolvent, there's sufficient residue to cover the cost of sequestration, and that sequestration will be to the advantage of creditors. So the court has discretion to grant or refuse the sequestration order. They can postpone or refuse if it's brought with an improper motive. So now let's talk about the process. So the process starts with the notice of motion and affidavit. The decision of the court is based on the documents, and the facts must be provided in the sworn affidavit. The document must be lodged 2 days before application. Now we move on to compulsory sequestration. This is where creditors apply for sequestration of the debtor. So the preliminary formalities before the court application is that the applicant must give security for the sequestration costs until the trustee is appointed. They must get a certificate for proof, and this should be done not more than 10 days before application. And then copies of the application must be sent to the debtor, SARS, and employees or trade unions if applicable. So in terms of the application process, it starts with the notice of motion supported by an affidavit. So in terms of compulsory sequestration, we have provisional sequestration. So the requirements to be met in court by the applicant creditor is that they comply with the formal requirements and that it's a liquid claim, so 100 Rand or 200 Rand jointly. There's reason to believe sequestration will be to the advantage of creditors. The debtor is insolvent or has committed an act of insolvency, and the claim is for an amount of money that's certain and determined, and by an order of court or agreement or otherwise. So when is a claim not liquidated? Well, if it's a claim to delivery of goods or claim to do something, or the amount of money is in dispute. So there's summons and then it'll be liquidated. A claim is also not liquidated if it's a claim for damages. Now let's take a look at all of the acts of insolvency. So this is if the person leaves South Africa and intends to evade or delay payment, or failure to satisfy judgment, so the sheriff gives nulla bona, or maybe the debtor disposes their property and prejudices or prefers one creditor, or maybe they remove or attempt to remove their property with the intent to prejudice or prefer. Another act of insolvency is an offer of arrangement with any creditor to release the debtor of their debt, so actual or attempt. Another is a failure to apply for surrender, so the debtor fails to follow through with voluntary surrender. Another is a notice of inability to pay, not unwilling, just inability. And then another act of insolvency is if the debtor is a trader and gives notice of transfer of their business in the government gazette and they're unable to pay debts. So you'll get a final sequestration order and then the return date and then proof of everything again. Now we move on to the second part of insolvency, the effect of sequestration. So the effect of sequestration is that the insolvent loses control of his estate. The spouse of the insolvent also loses control, but then the spouse of the insolvent can apply for release. So from the date of sequestration, control of the estate vests in the master until the trustee is appointed. The trustee will be able to sell and distribute the proceeds, and the insolvent always retains residual interest if there's assets or money left after the debt has been paid. So what's some of the property of the insolvent estate? Well, the general rule is that all property at the date of sequestration and all property acquired during or after sequestration forms part of the insolvent estate. So this is movable or immovable property wherever situated in South Africa, immovable property, and this could be land and every right or interest in land or minerals registrable. And then in terms of movable property, this is every kind of property or every right or interest which isn't movable. And this includes contingent interests in property. For example, a right of inheritance accepted by an heir vests in the insolvent estate. But now let's take a look at the insolvent's assets at the date of sequestration that are excluded from forming part of the insolvent estate. Well, this is immovable property outside of South Africa, if the South African court sequestrated the debtor. And this is also movable property outside of South Africa. And then some of the other stuff that are excluded are clothing, bedding, household furniture, tools, and other essentials. Property held in trust by debtor as a trustee. And then the attachment and sale of estate of a farmer is done with regard to the Land and Agricultural Bank Act. And then lastly, life insurance policy benefits where the policy was in force for 3 years are also excluded. So some of the assets acquired after or during sequestration that are excluded from forming part of the insolvent estate could be pension benefits, unemployment insurance, UIF, compensation for injuries or diseases at work, compensation for defamation or personal injury, and salary or wages. So but then what is the effect of sequestration on personal status of the insolvent? Well, they can't hold certain offices, for example, director, MP, trustee, credit provider, certain boards, etc. They can't do business as a trader who's a general dealer or manufacturer. They can't register as a manufacturer or provider of liquor. And they can't enter into certain contracts. But then what is the effect on unexecuted contracts? Well, the general rule is that the sequestration doesn't terminate the contract. So the trustee steps into the shoes of the insolvent, and the trustee has a right to elect either to continue or repudiate or cancel the contract. If the trustee elects to repudiate or cancel the contract, it's a breach of contract. But there's no claim for specific performance. So the third party can claim for damages as a concurrent creditor. Now we move on to impeachable dispositions. So what is a disposition? Well, this is any transfer or abandonment of rights to property, including a sale, lease, mortgage, delivery, payment, release, donation, or pledge. So let's first take a look at not made for value. So this is the disposition of assets that aren't made for value by the insolvent more than 2 years before the sequestration of their estate. And immediately after the disposition was made, they became insolvent. So the court can set it aside or cancel it. Another impeachable disposition is voidable preferences. So this is the disposition of assets made by the insolvent more than 6 months before sequestration and have the effect of preferring one creditor above another. And immediately after the date of preference, the debtor became insolvent, so the court can set it aside or cancel it. And the only defense is if it was done in good faith in the ordinary course of business. Another is undue preference. So this is the disposition of assets at any given time before sequestration made by an already insolvent debtor with the intention to prefer one creditor above another. So the court can set it aside or cancel it. So the last impeachable disposition we'll look at is collusion. So the debtor intentionally conspires with another creditor to prejudice the other debtor's creditors. Then the debtor disposes his assets, so the court can set it aside or cancel it. Now let's talk about the appropriation of proceeds and contributions. So here we have secured creditors. These are people that have a special bond over immovable property, a notary bond over movables, a tacit or landlord's hypothec, a pledge, or a lien. So the proceeds first go to the maintenance and realization costs of the real security, and then the remainder goes to the secured creditors. If the proceeds are insufficient, secured creditors become concurrent, and then the surplus is basically the free residue. So now let's talk about contributions. So this is if the free residue is insufficient. So the applicant creditor is liable to contribute, and then concurrent creditors contribute in proportion. We also have contributions by secured creditors that have proved their claims and relied on security. And then we also have statutory preferent creditors. And then in terms of composition, we have agreement between insolvent and creditors. We also have the common law, Section 119, and then the acceptance of offer. Now let's talk about rehabilitation by order of court. So this can happen 12 months after sequestration. This is after confirmation of the trustee's first account. And then 6 weeks notice of intention in the government gazette should also be given. And then if they've been previously sequestrated, this will be 3 years after confirmation of the trustee's first account, and then the notice should be 6 weeks to master and creditors. And then if they've been convicted, the rehabilitation can be 5 years after conviction and sentence took place, and there needs to be notice 6 weeks to the master and the creditors in the government gazette. And then if no claims have been proven and there's no conviction and it's their first sequestration, then 6 months after sequestration application, they can be rehabilitated. And then again, they need 6 weeks notice in the government gazette. And then if 50 cents of a rand is paid or security was provided, they can apply immediately. And then 3 weeks notice should be given, and then the copy of the notice should be given to the trustee, so registered in post or a handover. And then lastly, if all claims have been paid and the interest has been paid, they can apply after confirmation of the distribution account. Then 3 weeks notice should be given to the master and the trustee. But now let's talk about automatic rehabilitation. So this is automatic rehabilitation by passage of time, and this is 10 years, if there's no objections and no previous sequestration order was given. So but then what is the effect of rehabilitation? Well, all the debt before the sequestration falls away. They regain full contractual capacity, and if not all debts are paid, assets in control of the trustee must be sold and the money must be distributed. And you should know rehabilitation has no effect on the insolvent sureties, the rights of creditors with regard to composition, the right of a creditor to institute action, and the duty to pay a fine in terms of the act. So now we move on to the meeting of creditors. So in terms of the first meeting, the master convenes the meeting, and its purpose is to appoint or elect a final trustee and allow creditors to prove their claims against the estate. And then in terms of the second meeting, the master sets the date and the trustee convenes the meeting. Its purpose is to prove claims, receive trustee's report on the affairs and condition of the estate, and for the creditors to give the trustee directions as regards to the administration of the estate. Then we also get a special meeting, so the trustee convenes this meeting, and its purpose is proving claims and interrogating the insolvent, if the master gives consent. And then in terms of the general meeting of creditors, the trustee convenes the meeting. And its purpose is for creditors to give the trustee directions as regards to the administration of the estate not covered in the first meeting. Now let's talk a bit about the duties of the trustee. Well, they have to publish a notice confirming their appointment in the Government Gazette and call on all debtors to pay debts owing to the insolvent. They need to take charge of all movable property of the insolvent, have the goods valued, and then check whether a claim has been proved by a creditor in one of the meetings. And then they have to open a check account in the name of the estate, and then all monies of the estate will be paid into the account. And then they have to record all monies received and paid. Assets of the estate must only be used to benefit the estate. They also have to call a meeting if requested by a creditor. They should also investigate the insolvent's affairs and report back at the creditor's meeting. So they should report on the assets, liabilities of the estate, the cause and reason for their insolvency, etc. They should also liquidate and realize the estate assets on the instruction of creditors, distribute the proceeds and collect contributions where necessary. And then lastly, trustees should lodge a liquidation and distribution account. Now let's talk about the appropriation of proceeds. Well, the trustee has to liquidate or sell all the assets under their control after the second meeting upon the creditor's instruction, or by public auction or tender if no instruction is given. And then to be paid from the proceeds of the assets, a creditor must be a secured creditor. So basically they have a special bond over immovable property, mortgage, notary bond, hypothec, pledge lien. But, and there's a big but, before the proceeds of the sale are used to pay the secured creditors, they must first be used to pay the costs of maintaining and realizing the assets, and then the remainder is used to pay secured creditors. So the surplus that remains after paying the secured creditors is called the free residue. The free residue is first used to pay statutory preferent creditors, for example, funeral costs, deathbed, sequestration costs, salary, income tax, etc. And then whatever is left is used to pay the concurrent creditors. So if the proceeds are insufficient, the secured creditor becomes a concurrent creditor. So in terms of the types of creditors, we have the costs of maintaining and realizing the asset, and then we get to secured creditors, and they're paid from the proceeds from the realization of their securities. And then we move on to statutory preferent creditors, and then lastly we get to concurrent creditors, and they're paid from the free residue. And then the types of security conferring preference are special mortgages, landlord's hypothec, then a pledge, then a lien, and then installment agreement hypothec. Now let's talk about contributions, and this is where the free residue is insufficient to cover the cost of sequestration. So the applicant creditor is always liable to contribute. Concurrent creditors contribute in proportion to their claims, and then secured creditors who've proved their claim and did rely on security are only liable if there are no other creditors who can contribute. But then secured creditors who've proved their claim and didn't rely on security are only liable to contribute for the concurrent portion of their claim. Creditors who withdrew their claim against the estate are still liable to contribute for the cost of sequestration up until the withdrawal date. And then statutory preferent creditors under certain circumstances can also contribute. Now let's talk about composition. So we have the common law, so it's based on contract. And this is for a debtor who's been provisionally sequestrated, and it requires the approval of all the creditors to be binding. And the effect or advantage is that the debtor is released from all their debts and the consequences of sequestration. And then we also have agreement, and this is between the insolvent and creditors. So the debtor offers to pay the creditor a certain amount, and it'll be regarded as a full or partial payment of the creditor's claim. And then in terms of section 119, this is based on statute, and this is for a debtor whose estate has been sequestrated finally, and it requires 75% majority vote of creditors in number and value to be binding. So the minority creditors are bound by the majority vote. So the effect or advantage is that it doesn't need the participation of all the creditors, and then the disadvantage is that the sequestration order isn't discharged. So the debtor remains an unrehabilitated insolvent. Composition remains valid even after rehabilitation. All rights and duties of the insolvent are determined by the composition agreement. And again, let's talk about automatic rehabilitation. Well, this is after 10 years, and the insolvent is automatically rehabilitated by operation of law. And of course, this is provided the insolvent wasn't previously rehabilitated and there aren't any objections to the automatic rehabilitation. And then we also have rehabilitation by order of court, and this has the same requirements as the ones we looked at before. So then what is the effect of rehabilitation? Well, again, all the debt before sequestration are discharged or fall away. The debtor regains full contractual capacity, and if all the debts still aren't paid, assets in control of the trustee must be sold and the money must be distributed. And again, rehabilitation has no effect on the insolvent sureties, the rights of creditors with regard to composition, and then the rights of a creditor to institute action against the debtor on the duty to pay a fine in terms of the Insolvency Act.